So although in recent years, New York finally gained a form of no-fault divorce, people still ask about grounds, and we still do require grounds for a divorce. One is essentially irreconcilable differences, that the marriage has more or less failed for 6 months, but we still have on the books adultery. We also have cruel and inhuman treatment. We have abandonment, the subset of which is constructive abandonment, which if you were divorced 10 years ago or longer, most likely that is the ground on which your divorce was ultimately granted. So those are the various options that are available to us. It's not something that will have an impact on the outcome of the divorce in almost every circumstance, but something that it's good for you to be aware of. And if you have those questions, we're happy to answer them. In a New York divorce, the way assets are divided, it's under a system known as equitable distribution. Equitable from the word equity, meaning fair. So the role of the court, or in settlement, the goal is to fairly distribute the assets. To do that, it's a 3-step process. First, we classify the asset. We decide if it's considered marital property or separate property. If it's marital property, we're going to value it. And in the third and final step, it's going to get distributed. Separate property is anything that either party acquired before the date of marriage or that they acquire after the commencement of a lawsuit for the divorce. You can also accumulate separate property during a divorce. There's a few circumstances. If you inherit something, it comes to you as your separate property. If you have a personal injury lawsuit and you get an award for that, for the pain and suffering, for the injuries, that is your separate property. And if you get a gift from a third party, not from your spouse, it comes to you as your separate property. However, with respect to all separate property, it can get complicated because separate property can lose its separate nature. That's something that you really need to discuss the specifics with a divorce attorney. It's something that we're well equipped to do, and it's something that can be a critical part of a divorce proceeding and must be handled appropriately. When we talk about equitable distribution and dividing assets equitably, the question arises, what does that mean? What does it look like? The reality is, for the vast majority of assets in the vast majority of cases, courts are dividing assets equally in New York, 50-50. When I say courts are doing it, that's because that's often how cases are settled. Unless you're in the realm of mediation or collaborative, if you're in a litigated case, the odds are you're going to be dividing your assets 50-50. The one general exception to that general rule is with respect to businesses. Businesses are typically not divided 50-50. Alimony, also known in New York as maintenance or spousal support, is very fact-specific. Recently, in recent years, the New York legislature passed a law that gave us a formula, and the formula applies to only up to a certain level of income, to relatively modest income levels. Beyond that, and even with that formula, the formula is a guideline. It's not meant to be applied rotely to each case in the exact same way, so it becomes really fact-specific. The old rule, which still applies, is that the role of maintenance is to allow the spouse that's not self-supporting the opportunity to become self-supporting, if possible, at a level equivalent to what was enjoyed during the marriage. So when we are looking at maintenance and trying to figure out what's appropriate, we do look at the formula. We do look at your standard of living. We look at your assets. There's a lot of factors that go into that, and that's where each case is different. If you speak to your friend and they tell you they're getting a certain amount, that really probably has no relevance to what would be appropriate in your situation. Divorcing parties that don't have children is very different than a divorce when you do have children. Particularly young children, children under the age of 21, which is the age of emancipation in New York, children of college age. That greatly complicates the divorce. It means that there's a lot more issues that we need to address. We need to protect yourself, your relationship with your children. There are financial issues. There's where they're going to sleep at night, how are decisions going to be made regarding their upbringing, their medical care going forward, their education, their extracurricular activities. Some of the numerous issues that go into resolving a divorce where there are young children. If you have any questions whatsoever about divorce, please give us a call, Joseph Law Group PC. It's all we do. We're here to help. We're happy to help.